All right. And hello. All right. So this is Chris Berry, certified financial planner, certified LLC attorney with Castle Wealth Group. And we do these weekly wisdom webinars once a week, just answering questions clients or individuals or families submit. And we start with a positive focus. And my positive focus is that my kids are going back to school. So they both had their walkthroughs, or my son had his walkthrough yesterday, just got done with my daughter's walkthrough. Pretty excited that they're looking forward to going back to school. So they're good kids, excited to see their friends. All right. So with that, if you do have a question, legal, financial, tax question, feel free to put it in the Q&A. Got some questions already coming in. Let me pull up one that was submitted ahead of time. I'll share my screen. And it was a three-parter. Whoops. Hold on. Let me make sure I'm sharing the right thing. There we go. All right. So this question was with regards to, make it so I can actually read it. So this is all with regards to administering a trust. Whoops, that's way too big. All right. So I have a revocable trust. Person serving as successor trustee of the trust, kind of wrapping up someone's affairs. So first question, why do you recommend not giving a copy of the revocable living trust to the bank? Seems to me an expected request by a bank with a successor trustee has to distribute cash assets. And what is the ramifications of the copies provided to a financial institution? The reason is just the trust, it's a private document. No one is really entitled to see what the trust says per se, other than like the beneficiaries. The bank is taking instruction from you. It's not like the bank is there to oversee what you're doing. The purpose of the trust is to keep things private, keep things out of court. So that's why typically we don't give them a full copy of the trust. We just give them a certificate of trust. At least personally, like I don't like sharing information unless it's necessary, and a lot of clients feel similarly. So it's not necessarily bad if you share the whole trust, it's just not necessary. So, and it can just lead to additional questions and additional slowdowns. So it's not the end of the world if you share the whole trust. What I'm saying is it's just not necessary. Number two, a 401k through GM Benefits and Service Center is asking for original notarized trust documents. Is this necessary? What can be given in place of that? That's pretty strange to me. I'm guessing maybe it's someone who's new because think about it, if everyone asked for the original signed notarized trust copy, there's a good chance that that could be lost at GM Benefits or any other place. So the trust itself, I think there's language, if I'm not mistaken, that says they can take a notarized copy. So what I would give in place of that is, again, the certificate of trust. You can do a new notarized certificate of trust super easy. Because as an attorney, I can do a certificate of trust for a client. But there's only one original signed trust, and that's by dad who already passed away. So I wouldn't be giving anyone the original trust. I would give them certificate of trusts. And we can do a new certificate of trust showing that you're the acting trustee and have that notarized. And then we can have that as an original. Because again, the certificate of trust, it's like a stand-in. It's saying who the trustee is. It gives the name of the trust, the date of the trust. That's really all these financial institutions need to know is who are they working with? And that's you as successor trustee. As successor trustee, I have dad's title to his vehicle with a letter, loan payoff. I wish to sell his vehicle to the pastor. Can I do this directly? The vehicle is not listed in the trust. Yeah, so typically vehicles are not listed in the trust because there's a simple process at Secretary of State where you can transfer these to next of kin, like children, and there's no cost it doesn't go through probate or anything. So you walk into Secretary of State with the death certificate, they'll transfer it to next of kin, and you can go ahead and now the title's in your name. And then once it's in your name, you can go ahead and sell the vehicle or do whatever you want with the vehicle. So that shouldn't be a problem. So hopefully that's helpful. Let me see if I have, okay, a couple more questions here. Let me copy and paste it. All right, here's another question that came in. As we get older and our mental faculties decline, what options are available for turning over day-to-day financial management, bill paying, if there are no close relatives you want doing this? I.e., are there businesses that specialize in this and that can act as a financial power of attorney? What are the typical fees? So I'll take kind of one step back because we get this question asked all the time, like who should I name as like a power of attorney, financial power of attorney or successor trustee? And there's a hierarchy that typically we go through. So first we would look to family. So nothing's kind of stronger than blood. And when I say family, I'm not just saying like children or a spouse, but also think about siblings, cousins, nieces and nephews, some type of a family or blood bond. I always look to family first. Now that said, I don't have a huge family. Like I'm an only child, my dad's an only child. So there's not a lot of people that I can name in my plan. That brings us to the second in that hierarchy. I would look towards close family friends. So like I have a college roommate, he's a state trooper. I trust him. He could serve a role in my plan. Or my dad had a friend from way back in the day in college. He's known me as long as I've been alive. Like I could serve in their plan per se. So if not family, then maybe close family friends. But then if you don't have either of those, then you might get into professionals. Attorneys can serve, CPAs can serve. We certainly try not to serve in the documents that we're creating. Just I don't want it to look like we're kind of taking over too much power. But yeah, there are professional services that can serve this role. CPAs, bookkeepers, attorneys, and the fee that they're going to charge, it just kind of depends. Typically, they're going to do it on an hourly basis. Attorneys are probably going to be more of an investment than, say, a bookkeeper to serve that role. But there are professional services available. I don't necessarily have any off the top of my head, but there are people that will serve that role or serve as guardians, professional guardians. But again, now you're talking about fees and there's no real emotional connection. And you might be one of 250 other people that they're serving that role. So I always look to family first, and then if not family, then close family friends. Because keep in mind, you might not have a perfect answer, but whoever you come up with is going to be better than leaving the courts to decide. So I always like to remind clients of that, because worst case, something happens, you're incapacitated. Now the court's going to appoint a guardian or conservator, which could be a guardian who has like 250 other wards of the state that they're taking care of. And you're just going to be kind of a number to them. So that's why I always try to find family or close family friends. It doesn't even have to be local these days, especially with technology and stuff. If there's someone that's out of state, I would name the person who's out of state. That's better than leaving it up to the courts to decide. All right. And then the last one, this is really kind of more just for our clients. But the question is, do we need to do anything with investments now that TD Ameritrade is merging into Schwab? So really, no. So what's going to happen? What happened is, so we use TD Ameritrade as one of our custodians. Custodian is where your money is held. We don't physically hold any client's money. And there's a couple of major custodians out there. There's Fidelity, there's TD Ameritrade, there's Charles Schwab, there's another one that we use called Altruist. And so what happened was a couple of years ago, Schwab actually bought TD Ameritrade. And so we knew this merger was coming. And what's going to happen come Labor Day is that all the TD Ameritrade accounts are going to move over to Schwab. There's nothing necessarily that needs to be done or anything that's going to be different other than you're going to have a different login. And unfortunately, the account numbers are going to be different. But as we're moving into this transition, we're going to certainly be doing our due diligence to make sure all the beneficiary designations remain the same, the money is moving over in kind. But big picture, there's nothing you need to do other than you're going to have to create that new login at Schwab. So but we will be monitoring that for sure. All right. Any other questions? That's all I got. All right, going once, going twice. Oh, and we are back into doing our in-person workshops where we talk legal, financial, and tax planning in 3 easy steps. We have our workshops going on really all over Southeast Michigan at our different locations, whether it's Ann Arbor, Brighton. We have a Lansing location now, Bloomfield Hills. So if you're interested in kind of sitting down for an hour listening to us blabber on about death, taxes, and capacity, more of a structured presentation, we're doing these workshops about a couple times a week between me and our other team members. So if you are interested, just reach out to our office. But with that, here we go. One more question. So here, one more question about using certificate. How do I prove to them that I am indeed the successor trustee? All right, so here is another question. Let me just copy it into Word. Let me share my screen. All right, so follow-up question on the certificate of trust. One more question about the certificate of trust. How do I prove to them that I am indeed the successor trustee? Well, that's where the certificate of trust comes into play. So one of the things with it specifically says on that certificate of trust is it says the name of the trust, and then also it shows who the acting trustee is. So that's basically the whole point of the certificate of trust is to notify the bank or financial institution that the person that you are the person that can act. So that's the sole purpose of that certificate of trust. All right. And again, if you logged on late, we always have these on our YouTube channel. So if you Google like Castle Wealth Group, legal YouTube, usually within about a day or so, you'll be able to find the wisdom webinar, full recording. Okay. All right. With that, thank you, everyone. Take care. Bye-bye. 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 Whoop, hold on. Okay. All right. Bye-bye. We're out.